Hello, I'm Olivia and welcome to this Kids Send Information Advice and Support Service video on the EHCP Annual Review process. The aim of this session is to help you understand and have confidence navigating the annual review process for your child who has an education, health and care plan. We will cover the basics of the annual review, the process and the different local authority decisions. All our information today has been taken from the Children and Families Act 2014, the SEND Regulations 2014 and the Code of Practice 2015. I've also included some relevant case law as well. I'll be unable to comment on any particular processes and procedures relating to your local area. If you do have any questions, I have popped a link in the description below with a service finder to help you find your local SENDIASS service. Okay, so let's have a look at the basics. So who can have an annual review? Well, any child who has an education, health and care plan will have an annual review. The annual review is a statutory process of reviewing a child or young person's education, health and care plan, looking at the needs, the provision and outcomes within the plan before deciding if any changes need to be made. The education, health and care plan will be reviewed annually. The first review will happen within 12 months of the plan being finalised and then within 12 months of any previous annual review. There are two caveats to this rule though. So the first is where there is an educational phase transfer. The first deadline is the 15th of February. This is for any child who is moving from nursery to primary school or primary school to secondary school. The annual review process must be completed, including naming the new educational setting by the 15th of February of the calendar year your child is making that transfer. Where the transfer is between secondary school and that post-16 provision, the annual review process must be completed, including naming the new educational setting in the final plan by the 31st of March of the calendar year of the transfer. The second caveat is where you move between different local authorities. In this circumstance, the local authority, your new local authority, must conduct an annual review either within 12 months of the previous annual review by your old local authority or within 3 months of the education, health and care plan being transferred from the old local authority to the new local authority, but it's whichever is the latest date. Something worth noting here as well is that the new local authority may, on the transfer of the education, health and care plan, bring forward the arrangements to review the plan, and they may even conduct a new education, health and care needs assessment regardless of when the previous assessment was completed. And that's mentioned in paragraph 9.160 of the SEND Code of Practice. An annual review is the process with multiple steps. It isn't just the meeting, and all the steps have to be followed in order for the annual review to be completely completed. It's worth noting before we go into detail, there are some slight differences depending on whether your child is attending an educational setting or whether your child is not attending an educational setting. As we go through, I have identified these and I will be explaining these as well. So the first step in the annual review process is requesting up-to-date information. Advice and information about the child and young person must be obtained and circulated at least 2 weeks before the annual review meeting. If your child is in an educational setting, the responsibility of this falls on the educational setting. If your child is not in an educational setting, this is the responsibility of the local authority. The table up here outlines who will be requested to give information as part of the annual review. You will see for a child who is in an educational setting, the educational setting themselves will provide information. However, for those who are not in an educational setting, but the local authority may ask other people who they feel are appropriate. Okay, so that's step one. Step two is the invitations. Now you must be given at least 2 weeks' notice of the annual review. For children in education settings, it is the role of the educational setting, so the school, the nursery, the college, to take lead on the annual review and send out the invitations. Again, if your child is not within an education setting, this will come from the local authority. Again, on this table, you will see there are slight differences in terms of who will be invited to attend the annual review. Essentially, everybody who's been requested to give information as part of the annual review will be asked and invited to attend the annual review meeting. So now let's look at the meeting. The focus of the meeting should be on the progress towards the outcomes specified in Section E of the Education, Health and Care Plan, whether any changes need to be made to the help and support specified in Section F to ensure that the outcomes in Section E are achieved. Consideration can also be made to whether the outcomes within the plan may need to be changed themselves. For a child who is in Year 9 or above, the meeting should also consider what help and support is needed to prepare this young person for adulthood and independent living. For young people aged 18 and over, the local authority must also consider whether the educational training outcomes have been achieved. So step 4 is the annual review report. Now, once the meeting has been completed, the school must send the annual review report to the local authority and everybody else who was invited to that meeting. So remember that table a few slides ago, everybody on that table within 2 weeks of the annual review meeting. For children who aren't in attendance at an educational setting, the local authority are the ones responsible for the report, as they are the ones who have conducted the meeting. Again, the report must be sent out to everybody who is invited to the meeting, and that includes you as parents as well. Okay, and all this information is set out in the SEND regulations, Regulation 21, Part 8. Okay, but what does this report need to include? Well, it must include any recommendations of any changes to the Education, Health and Care Plan, make reference to any differences between professional recommendations, and it must include all the information and advice sought in step 1 of the annual review process, the local authority decision. So the local authority have 4 weeks from the date of the annual review meeting to make a decision whether it's going to A, maintain the plan in its current format. Option 2 is to amend the plan. Or the third option the local authority can take is to cease to maintain the plan. This decision that the local authority makes must be communicated to the parents within 4 weeks of the annual review meeting. Now let's talk about those different local authority decisions in a little bit more detail. So where the local authority chooses to maintain the plan in its current format, there will be no changes to Section B, the special educational needs, Section E, the outcomes, or Section F, the support specified in the plan. The Education, Health and Care Plan will continue as it was. The local authority must notify you of its decision to maintain the plan as it is, and they must also give you details on your right to appeal, your time frame for lodging an appeal, the requirement to consider mediation, and the availability of SEND information, advice and support services, as well as disagreement resolution services. Another decision the local authority could make is cease to maintain the Education, Health and Care Plan. The local authority can only do this if they determine that the plan is no longer necessary to be maintained, or if they, the local authority, are no longer responsible for the child or young person. The circumstances where the local authority may determine that a plan is no longer necessary include where the special educational provision, so that's the help and support defined in Section F, is no longer required to be specified within the Education, Health and Care Plan. The second circumstance relates to where the young person is aged 19 or over. The local authority must take into account whether the educational or training outcomes in the Education, Health and Care Plan has been achieved. It is worth noting here that it is not automatic that the Education, Health and Care Plan will be maintained until the young person is 25, 18 or even 16. As you can see, after every annual review, the local authority makes one of 3 decisions, and it could be a cease to maintain decision if the local authority determines that the plan is no longer necessary to be maintained, potentially because the support specified in section F is no longer necessary to be specified in accordance with an Education, Health and Care Plan. So where the local authority are considering this decision to cease to maintain, they must inform and consult with the parent or the young person and consult with the educational setting currently specified within the Education, Health and Care Plan. Where after the consultation with the parent, young person and the educational setting, the local authority decides to cease to maintain the plan, they must notify the following people of its decision: the parent or young person, the educational setting currently named in the Education, Health and Care Plan, and the responsible CCG, the Clinical Commissioning Group. In notifying the parents or young person of their decision to cease to maintain, the local authority must inform the parents and young person of their right to appeal, the time limits around appeals, the requirement to consider mediation, and the availability of SEND information, advice and support services and disagreement resolution services. It's worth noting here, where the parent or young person disagrees with this decision, the local authority must continue to maintain the Education, Health and Care Plan until the time limit for lodging an appeal has ceased, or where an appeal has been lodged, the appeal has been concluded. The final decision the local authority can make is around amending the EHCP. If the local authority makes this decision, they must send the parent or young person a copy of the proposed amended Education, Health and Care Plan and supporting evidence, the notice of their right to request a particular school or institution, and where the parent or young person can find information about the different schools and colleges available. In doing so, the local authority must give the parent or young person at least 15 days to make representations on the copy of the amended Education, Health and Care Plan and to name their preferred educational setting. They must also give the parent or young person the opportunity to request a meeting with an officer from the local authority if the parent or young person wishes to make their representations orally. Where the local authority agrees to amend the plan following the representations, the local authority must finalise the plan and send a copy to the parent or young person, the school named in the plan, and the responsible commissioning body. This has to happen as soon as possible or within 8 weeks of the parent or young person receiving a copy of the proposed amended plan. The local authority must also provide the parent or young person with notification of their right to appeal, the time limits for appealing, information relating to mediation, and the availability of SEND information, advice and support services and disagreement resolution services. There has been a case law update in relation to annual reviews, particularly around the decision to amend the plan. So at the same time that parents are notified of the decision to amend the plan, the local authority must also provide the parent or young person with the details of the changes they are proposing. So this now means that 4 weeks after your annual review meeting, if the local authority have decided to amend the plan, not only must you receive the letter notifying you of its decision to amend the plan, you must also receive a copy of the notice of amendment. There is no change in relation to the timescale of issuing the final plan following the receipt of the draft plan or notice of amendment, and therefore the final plan must be issued as soon as practicable and within a further 8 weeks maximum of the parent or young person receiving the draft plan. But the change in timescale in relation to issuing the draft plan or the notice of amendment now means the final amended plan must be issued within 12 weeks of the annual review meeting. This is the end of the information around annual review processes. Should you require any more information, advice or support around the annual review process, please contact your local SEND Information Advice and Support Service. They will be more than happy to help. To find your local Information Advice and Support Service, there is a link in the description for you to use.